Good morning, highly distinguished participants of the webinar and all who watch us, both in Latvia and abroad. I'm really pleased that today we have been able to meet each other. I'm especially grateful for the opportunity to connect today with the President of the Court of Justice of the European Union, Mr. Cohen Leonards, and the Judge of the Court of Justice of the European Union, our beloved Madam Ineta Ziemele. I'm equally pleased to see my dear colleagues, judges of the Constitutional Court of Latvia, as well as the Chief Justice of the Supreme Court of Latvia, Mr. Aigars Strupišs, and the judges of the Supreme Court. Welcome to our conference. Unlike the other public debates that are aimed at reaching out the general public, today's meeting is more of a dialogue between the judges themselves. A dialogue that is aimed at finding common points between the Constitutional Court, the Supreme Court, and the Court of Justice of the European Union. A dialogue that would contribute to our work in advancing our common values, first of all, the rule of law. We very much appreciate the participation of the Court of Justice of the European Union in this debate. The ECJ has the prerogative of interpreting the treaties and the secondary EU law in a way that is binding to us, the courts of the member states. At the same time, we, the courts, are equally responsible in ensuring effective legal protection of the rights covered by the EU law. The supranational perspective of the ECJ in today's debate will be of a great value to us. We are also happy to welcome the Supreme Court of Latvia today. In applying EU law, the Supreme Court is one of the most active courts in Latvia in referring to the ECJ for preliminary rulings. These requests relate to the issues which constitute important case law for the entire legal space of the EU. The Constitutional Court of Latvia is also actively participating in the development of a common European legal space. In our judgments, we directly apply the primary and secondary EU law. Where applicable, we interpret the fundamental rights written in our Constitution by specifying these rights in the light of the EU law. In our jurisprudence, we analyze the scope of respective directives and regulations in order to determine, for instance, whether the contested national legal norm falls within the scope of the relevant EU law. The tendency in the recent years has been that the applicants to the Constitutional Court more and more often refer to the provisions of the primary and secondary EU law in order to prove the violation of the fundamental rights guaranteed by the Latvian Constitution. Last year, the Constitutional Court has referred to the ECJ for preliminary ruling requests. Ladies and gentlemen, today's topic on the one hand is very nuanced in legal terms, but on the other hand, it is of great importance. In essence, we want to discuss how to more effectively ensure the protection of the rights of our citizens, who are also citizens of the EU. The aim of the conference is to discuss the modalities of the application of EU secondary law by the Constitutional Court when exercising its competence to verify the compatibility of provisions of national law with legal provisions of a higher legal force. Our aim is to discuss all these questions from the unique perspectives of all three courts represented today. We will have 15-minute presentations by 4 speakers, followed by an open discussion. Speakers have chosen to have a direct dialogue in English. We also have the Latvian interpretation available. And now, for opening remarks, I would like to give the floor to the President of the Court of Justice of the European Union, Mr. Cohen Leonards. Please, floor is yours.
Thank you very much, President Osipova. Esteemed fellow justices, dear friends and colleagues, first of all, I take this opportunity to thank the Constitutional Court of the Republic of Latvia for its kind hospitality in organizing today's webinar on the role of the Constitutional Court in ensuring the conformity of national law with EU law. Despite the fact that the ongoing pandemic unfortunately requires us to discuss this topic of pivotal importance only in a digital format, I very much welcome the recent initiative of President Osipova to strengthening the bilateral relations between the Latvian Constitutional Court and the Court of Justice of the European Union by means of this webinar. In this context, it goes without saying that the arrival of our well-esteemed colleague, Judge Diemele, in the Grand Duchy of Luxembourg will certainly facilitate the formal and informal contacts between the Court of Justice and the Sadversmes Tiesa. In the framework of the EU's integrated system of judicial oversight, it is both for the Court of Justice and for the courts and tribunals of the member states to ensure the uniform interpretation and application of EU law. To attain that objective, on the one hand, it is for the Court of Justice, which has been created for that purpose by the member states, to say what the law of the European Union is. On the other hand, it is for the national, including constitutional courts, to apply that law to the cases that come before them, notably when reviewing the compatibility of national legislation with European law. This is why the preliminary ruling procedure provided for in the treaties under Article 267 of the Treaty on the Functioning of the European Union has developed into the most fundamental mechanism of the European legal order, since it allows precisely for a formal dialogue between the national courts and the Court of Justice on the correct interpretation and application of EU law. In 2020, out of the 735 incoming cases that were brought before the Court of Justice, 556 have been preliminary rulings, which means 75%, out of which 17 have been referred to the Court of Justice by Latvian courts and tribunals, 4 of them from the Sadversmes Tiesa. However, in order for that cooperative mechanism to succeed, there must be a culture of communication, trust, and comity between the different courts involved, which is the reason why informal contacts between judges of the member states and of the Court of Justice, such as today's webinar, are considerably contributing to securing the particular nature of the European legal order. With that being said, I would like to thank you very much again for having organized today's webinar, and I look forward to our discussions.
Skaņa. Yeah. Thank you, Mr. Leonards, for your kind words. Now I would like to open the presentations. I give the floor to my Vice-President of the Constitutional Court of Latvia, Mr. Aldis Laviņš, please.
Good morning, dear presidents, Mr. Leonard and Mr. Strupiš. Good morning, my dear colleagues from European Court of Justice, from Constitutional Court, and as well from Supreme Court. And good morning for everyone who follows to this conference. First of all, let me share a small emotion. Of course, I wish we could meet each other in person, but reality, unfortunately, says we have to be patient. And thanks to modern technologies and our staff who have organized this conference and who give us this opportunity to meet online and to discuss important issues. Before I start, I would like to apologize in advance that the focus of my speech about the dialogue between national courts and European Court of Justice will be focused from the perspective of national law. If we look back to the last couple of years, we can see that the applicants are becoming more and more eager to refer to EU law in their pleas and arguments. Consequently, the Constitutional Court more and more have referred to the Court of Justice seeking for preliminary ruling. And when you deal with some legal issues, it is quite obvious that some questions arises. And we do have some questions, and we are happy about this opportunity to discuss these questions. And now I am going to explain why the questions we have sent to you, Mr. Leonard, preoccupies our minds. Let me start with a general description of the role of the Constitutional Court in Latvia. So this court reviews the constitutionality of laws and other legal acts. Its scrutiny goes only as far as the points of law are concerned, which means the court does not review the points of fact. The Constitutional Court's duty is to ensure that in the national legal system there are no legal rules contrary to the Constitution or other rules of a higher value. No doubt that the Constitutional Court is also a part in the mechanism of shared competence under Article 267 of the treaty. It follows that there is also a duty of this court to provide for a remedy against rules of national origin contrary to EU law. Thus, let me pay attention to the possible approaches how the Constitutional Court takes into account the EU law. The starting point is the competence allocated to the Constitutional Court. At first, I would underline that EU law is neutral as to the scope of competence which may or may not be at the disposal of a national constitutional court, where it reviews the legal rules of EU origin. As well, the national legislator hasn't provided for any specific reference concerning the competence of the Constitutional Court in relation to the EU law. But at the same time, the national legislator has provided that alongside the competence to review whether legal norm is consistent with the Constitution, the Constitutional Court has the competence to review whether a rule of a lower legal rank is compatible with a rule from a higher rank. Now, we have to look at the question, what is the position of EU secondary law in the hierarchy of the Latvian normative system? Most likely, there is no straightforward answer. I can mention, for instance, the Latvian Administrative Procedure Law says that, and I quote, provisions of EU law shall be applied in accordance with their place in the hierarchy of external legal acts. So, it shows that EU secondary law is not viewed as merging under one hierarchy with the rules of a national origin. On the one hand, it is explicable because the authority of this hierarchy stems out of the legal force of a national rule. But, on the other hand, the EU law and its secondary legislation is an integral part of national legal order as well. Thus, the application of EU rules may not depend on their position in the hierarchy of national rules. In reality, the EU rules are applied solely according to the principle of primacy and effectivity of EU law. Dear colleagues, at the first glance, such an answer could lead us to the conclusion that the Constitutional Court does not have a competence to review the legality of national law against EU directives and regulations. But then, how can the Court fulfill its duty under Article 267 of the Treaty? This issue is resolved by the Constitutional Court in a rather general way. In its jurisprudence regarding EU law, the Court has stated that, and I quote, the national legal rules are to be interpreted in such a manner as to preclude contradictions with the obligations upon the Republic of Latvia under the European Union law, as far as these obligations respect the fundamental principles of the Constitution of Latvia. So, this legal position has a decisive role. As it has already happened in the practice of the Court, even where the Court does not decide on its competence regarding the EU law, still this Court may take into account the EU law in two ways. Firstly, in order to clarify the content of a national rule, and secondly, the rights and protections guaranteed by a provision of EU secondary law. The Constitutional Court includes under the scope of particular fundamental right embedded in the Constitution. However, this latter approach should be followed with some caution. In Latvia's legal system, we prefer to avoid that the content of a fundamental right under the Constitution becomes dependent on the interpretation of the EU secondary law. In such a case, I am afraid that we reduce to some extent the meaning of the text of our Constitution, or at least it becomes subject to a further change, since the scope and the content of EU secondary law is not immune to possible forthcoming changes, such as the interpretation given by the Court of Justice of the European Union, and even more, it may be simply annulled by the same Court of Justice. And, by the way, colleagues, when we met with colleagues from Bundesverfassungsgericht, they as well are not supportive with this approach. Now, let's look whether there are some other approaches. Another option for the Constitutional Court is to recognize its competence to review whether the national law complies with the EU secondary law. But we have to be aware of possible consequences. Firstly, in my opinion, such approach to some extent, could affect the legal dialogue between the Constitutional Court and the Court of Justice of the European Union. And secondly, it could change the competence of the courts of general jurisdiction towards the Constitutional Court and the Court of Justice of the European Union. I mean the following point. For instance, if a civil court faces with a contradiction of a national law and EU secondary law, it will have a duty to suspend adjudication in civil case and pose a question to the Constitutional Court about legality of the national legal norm. Therefore, dear colleagues, at least the principle of legal security requires that in our conference we devote some time to discuss it. Indeed, the national legislator, when creating the Constitutional Court, was following the so-called continental European model, where the Constitution is the yardstick against which to measure the legality of each and every norm. It explicates the Constitutional Court's duty to eradicate from the national legal system any legal rule which happens to be contrary to the Constitution or to the legal norms of higher value, including EU law. This solution is based on the idea that in democracy under rule of law, all legal norms are consistent with each other. If the Constitutional Court anyway denies its competence to review compliance with the EU secondary law, the goal to ensure the unity of the legal system will not be reached to the full extent. For instance, if the correct transposition of a directive is in dispute and the courts of general jurisdiction or the administrative court takes the correct decision to disapply the national rule which is contrary to EU rule, it will not change the fact that at least formally the defective national rule continues its existence as long as the legislator does not decide to modify it. Following that, personally, I'm inclined to support the position that the Constitutional Court has a competence to exercise the hierarchy review of a national rule against a provision of EU secondary law. Where the Constitutional Court acknowledges its competence, the EU law may serve as a yardstick of the constitutionality review in at least two different ways. The first way is to look at the EU law as stemming out, and now I quote, stemming out of international agreements which are not in conflict with the Constitution. This was a quotation of the law on Constitutional Court. So, it derives from the following legal idea. Since Latvia has ratified the Treaty of Accession to the European Union, Latvia has also recognized the EU secondary law as binding. In other words, secondary EU law would be considered as an extension of the EU treaties. This approach is compatible with the concept that the Constitutional Court in Latvia is competent to exercise both the constitutional and conventional review. And, dear colleagues, the second approach is to look at the EU law as any norm of a higher legal force comparing with national statutory law. As regards the first solution, I should mention that recently it has earned favor of the court, but towards the second solution, there is rather reluctant attitude from the court. Dear colleagues, regardless of which approach would prevail, I have to point out some risks related with the above-mentioned approaches. In order to verify compliance with the EU secondary law, the Constitutional Court itself would first to determine the content of particular directive or regulation. This fact alone, that the Constitutional Court does not refer to EU law, this fact alone, that the Constitutional Court does not refer to the Court of European Justice, may lead to a divergent interpretation of EU secondary law. After all, reasonable people could always disagree with an interpretation given by the Constitutional Court. Therefore, all divergences cannot be avoided merely by correct interpretation of law. And I wonder whether this means for the Constitutional Court that it should always seek for a preliminary ruling from the Court of Justice whenever it confronted to a disposition of EU law, even where the requirement from the Silphit line of case law would be satisfied, which, again, in my opinion, is a fertile soil for discussion. In the conclusion, I would like to emphasize that the aforementioned different approaches in the exercise of its competence relating to EU law have not precluded the Constitutional Court to ensure an effective protection of the applicant's rights, as well as the effectivity and uniform interpretation of the EU law. But I believe that comprehensive understanding of different approaches would enhance the quality of the dialogue between Court of Justice of European Union and the national courts, which in turn would foster the reaching of the ultimate goals of European Union and its member states. Which of these approaches are the most compatible with the aim to ensure and maintain EU law across European Union? How to deal with the risks related to the application of above-mentioned approaches? These are questions we would like to discuss in our conference. Thank you, dear colleagues. I hope we will have a fruitful discussion.
Thank you, Mr. Laviņš, for your presentation. Now I would like to give the floor of the Chief Justice of the Supreme Court of Latvia and the Chair of the Latvian Judicial Council, Mr. Aigars Strupišs. Please, floor is yours.
Thank you. Dear colleagues, dear guests, first of all, allow me to extend my sincere appreciation for this opportunity to speak at this venue. The topic is forever important and always acute. The role of the Supreme Court in maintaining the judicial dialogue with the Court of Justice and the Constitutional Court can't be emphasized enough. And an excellent example, and I would even say a staple case for this dialogue, is so-called Drozdov's case, where the combination and synergy of all three courts showed. We made preliminary ruling requests to the Court of Justice about the interpretation of a directive. When afterwards, receiving the answers, we referred the case to the Constitutional Court, which set aside the incompatible regulation of the Cabinet of Ministers. And this is a perfect illustration of the synergy among different areas of judiciary in the current European judicial setting. And I really emphasize this as a staple case, which shows how it should work. In 2020, Latvian courts referred 17 preliminary questions to the Court of Justice and submitted 20 applications to the Constitutional Court. Of those, 5 and 3 respectively were submitted by the Supreme Court. Altogether, over all these years, the Supreme Court has made 61 preliminary ruling requests to the Court of Justice and 15 applications to the Constitutional Court. These may not seem to be big numbers over the time. However, courts take very prudent approach to such a responsible step. Those references to the Court of Justice are always drafted with high responsibility after all the necessary homework is done regarding research and formulation of questions. And still, there are always new modalities of application of the EU law to be learned from each preliminary ruling that we receive. Today's topic is about application of the EU secondary law, but from the perspective of the EU law, I would say primary law is the concept where we mostly encounter constitutional issues on the level of principles. But regarding the secondary law instruments, that is more about method and technique. And one of the issues that we face most often, and which I'd like to refer to and review in today's speech, is how to assess the compatibility of national regulation with the EU law, and more importantly, what are the issues for us dealing with it. I will take a look more from system point of view, since this is an issue which I am preoccupied right now as the chairman of the Judicial Council also, but this is a very important, how Latvian judges, Latvian national judges, how they perceive this common judicial space. I'm afraid I won't be able to tell you much that you would not already know regarding this. However, I feel that sharing a few of my thoughts and observations might help us to map a path to a better understanding of the current state of affairs in Latvian judicial community regarding this important topic. Basically, assessment of compatibility of national regulation with the EU law stems from the understanding of the legal scope of the applicable legal act itself. It seems not so hard, however, sometimes even rather obvious situations pose problems to judges. And the problem is to learn how the legal clause should be assessed and what method is to be used for the assessment. When we are dealing with the national law, we mostly know the answers, mostly. We know the sources of the national law, we know the system, we know the hierarchy, and we know the legal method. We know how to assess constitutionality, compatibility, and it's in our blood as lawyers to know the hierarchy of the legal sources because it's considered to be a backbone of our legal method. But it becomes the whole new story when we meet the EU law. The Treaty on the Functioning of the European Union gives us a guidance regarding different types of legal acts and their effect, but it doesn't provide us with a clear hierarchy of them. And the answer as to why it is so, the answer is rather obvious. This is a complex legislative framework, and this complexity, unlike in national law, is hidden in divided competencies and in different legislative procedures, rather than in hierarchy, which is so native and dear to the classical legal mind of a national lawyer. And this is the first challenge our judges are facing. Although this gradually becomes somewhat less of an issue with every new generation of judges entering the judiciary, it's still there. For instance, let's not forget this remarkable case of Volker and Markus Schecke and Eifert on data protection, which showed that legality of an EU regulation, which is by many judges regarded as having higher effect because it's directly applicable, but it can be assessed against the clause of directives, which again gave the whole new dimension to the legal system, helping, among other things, to dismantle traditional hierarchical legal thinking when dealing with the EU law. Another issue is that, although I'd like to say that the method used by judges as their daily tool is generally clear, the practical application of some ideas and some principles, such as principle jura novit curia, which is the court knows the law, might be a challenge. And it becomes increasingly challenging nowadays to navigate even just through the national legal jungle, which is growing and becoming more and more complex and entangled by the day. And yet, as if that's not enough, there is still a huge and complex supranational legal system based on principles, some of which are a bit strange from the national law point of view, and the lack of hierarchy, which I just mentioned, being just one of those things. The Supreme Court mostly, of course, applies national laws, though we have to keep in mind that in that national legal act that we apply, a piece of EU law may be implemented. And although Latvian legislator usually supplements the national act with the reference to the EU directive, it's just a general reference usually. And for the complete picture, we still more often than not have to look into annotations and other preparatory documents of the legislative process. The legal databases, although are providing us with lots of documents, they really guide us quickly towards a clear solution on finding the appropriate legislative acts. Using minutes of meetings and explanatory reports both from the EU side and national side requires patience and also some degree of luck. In complex legal frameworks such as this, such as legal aid, taxes, customs duties, we find different legal concepts which sometimes confuse our minds, like basic regulations and implementing regulations. We find regulations amending several regulations and directives, and this certainly does not make a national judge's life easy. In order to ensure for the judge to know the law, it requires focusing upon both legal education in universities and professional training and specialization of judges. And what's particularly important here is that neither training nor specialization can take the old school approach anymore. Education, taking into account that enormous and still growing amount of detailed legal regulation, should be more principle-based rather than detail and technicalities-based. And just about like the guidelines established by the Court of Justice on reading the article, quote, in the light of directive scheme, or assessing something in the light of directive's objectives, this is the approach which is based on principle. And this legal thinking is slowly turning from details towards seeing context of principles, or so to say, the light. Whereas the specialization should not succumb to losing the general picture of the legal system. Because I personally do not quite trust a specialist who has extremely deep knowledge in one narrow subject at the expense of being blind to the whole picture. And what I see, it's increasingly challenging to maintain these two things in balance under the current trends of overregulation. Now, if this picture seems not already complex enough for you and still does not particularly appeal to some adventurous legal eagles, there is yet the concept of direct effect, which is a story in itself. I will skip here the details of Franklin's doctrine on direct effect of non-transposed directives and application of principles of the state liability for what the courts are responsible in line with the Kobler judgment. And also issues concerning horizontal and vertical direct effect is a separate topic in itself. We actually have very few examples where we had to apply directives directly instead of national laws, as would be required by the primacy principle. Therefore, the obligation to disapply any provision of a national law being contrary to a provision of the EU law having direct effect, for us, it's a rather theoretical question at the moment. By the way, regarding this direct effect, there is an interesting case currently before the Supreme Court in which we ask the Court of Justice for preliminary questions. This is the case Euromin Holdings Cyprus, in which the Court of Justice has gently reminded us that we have to assess whether a rule of the EU law intends to confer rights on individuals rather than to concentrate on the technicalities of direct effect itself. So we have to look into the essence, into the principle. Meanwhile, we should not forget that almost nothing in the legal world is carved in stone. There's always a possibility to revisit previous doctrines. And here it is important to acknowledge that in the dialogue with the Court of Justice, we are free to raise our concerns and even to come back for further clarifications, or where we would like to disagree, and ask the Court of Justice to reconsider its approach. I might note a recent request by the German court regarding possible direct effect of the same clause of the directive as was already requested a few years ago on the motorways fees. And the Court of Justice noted that since the first request of the direct effect was created by amending this clause, and now an individual may rely on it directly before the national court. So previous answer differs from the current answer because changes happen all the time. Or about this coming back for further clarifications, or where a court would like to disagree and ask the Court of Justice to reconsider its previous approach, we might refer to case Tarico and subsequent cases, a case of MAS and MB, which basically in substance are about direct effects of the Article 325 of the treaty, and in which the Court of Justice in fact recognized the importance of balance between EU principles and national application measures. I won't take much of your time, but concluding remarks, how I see this symbiotic and how we complement each other in this creating the common European legal system, I would like to say a few more things. We all are European courts, no matter what's the title, because we are all in Europe. Therefore, we have to be brave to interpret EU law, apply it, and draw conclusions. And it's important to keep in mind that we have some division of powers and competences, but we, as European judges, we are together responsible for the common legal order. However, each of us carry out their own responsibilities. But these separate responsibilities should be carried out while respecting the common judicial mapping. And our division of power and competences is a particular and important aspect of this picture. As I tried to show from the national judge perspective, to be a European judge nowadays is a task not for faint-hearted or simple souls, because complexity is enormous and it's growing, and the training is the key issue here. And regarding this training, I can't emphasize enough the crucial importance of it. And new approaches, new methods of training must be sought and must be implemented. And our Judicial Council has recently taken this issue by the horns, initiating reform in the judicial training. We are doing our best, and all together we will make this system work better and better. In conclusion, I would like to thank the Constitutional Court for organizing this seminar, and the President Leonards and President Osipova, as well as Judge Ziemel and Judge Lavinch for their contributions we heard and we will hear today. And also, I encourage my colleagues from the Supreme Court participate today with questions, to be active and use this opportunity to ask questions to our distinguished speakers from the Court of Justice, Constitutional Court. Thank you for the attention.
Thank you, President Strupiš, for your presentation. Now I would like to give the floor to the President of the Court of Justice of the European Union, Professor Cohen Leonards. Please.
President Osipova, well, I followed very carefully the two impressive presentations given by Vice President Lavinch and Chief Justice Strupiš. In fact, they raise all the questions which we indeed should be discussing in this webinar. And I noted with satisfaction that, like Chief Justice Strupiš just said at the end, that we bear this common responsibility. That is the message throughout the two speeches we heard so far. The judicial system of the European Union is resting first and foremost on the national courts and tribunals, and additionally on the Court of Justice of the European Union. If I were to make the image of an iceberg, it's the small visible part at the top, which might be the Court of Justice. But the huge invisible part is all the national courts and tribunals, which are the main interpreters and appliers. I insist, also interpreters and appliers of European Union law. Why do I say that? Well, by the way, my image of the iceberg is a little bit defective in that the Court of Justice is not hierarchically at the top. So I underline this. It's only quantitatively to mention the visible part as opposed to the invisible part. That's the only reason why I used that image. It's not a matter of hierarchy, and I really mean this deeply. The Court of Justice is the sort of gesetzliche Richter in the German constitutional tradition, the lawful judge, to have the final say on what European Union law means. But the national courts and tribunals are making their part, and you can see it in the system of references for preliminary rulings. It is the task of the national courts to identify the rules and principles of European Union law which might be relevant in the case pending before them. How can you identify the possibly relevant rules of Union law without making an initial interpretation of these rules? That is impossible. So that is why, since slightly over 10 years now, the Court of Justice, and I refer here to Opinion 1/09 about the international court system for the European Union patent, where the court has started to say expressly that it is for the national courts and tribunals and the Court of Justice to interpret and apply Union law. Now, this is for a second reason important. Not only that national courts and tribunals cannot identify the relevant rules of Union law without initially interpreting them, but there is a second strand in this co-responsibility for the interpretation of Union law. That is that national courts, be it national Supreme Courts of the general jurisdiction, like the Supreme Court of Latvia, or national constitutional courts, they should let their own light shine on the matter. So referring a question for a preliminary ruling is not just, and again, a somewhat dared analogy, like a student asking a professor after class some additional information on what he or she exactly meant. I mean, the professor. That is not how it is to be understood. It's the national courts which are the proximity courts to the litigants. They also are embedded in the national legal system and the national legal culture. European Union law is automatically part of the law of the land. In some countries, some member states like Latvia, that is even anchored in the constitution. In other member states like Belgium, my member state of origin, it is not at all anchored in the constitution because since ages we have a monistic approach, and everything which is validly in order, even in international law, is automatically part of the law of the land. So you see here that each member state follows its own legal tradition, and that's fair enough. There's no problem with that, to ensure the outcome of Union law being part of the law of the land. And this has been fully integrated in Latvian legal culture, as we could hear from the really impressive contribution by Chief Justice Strupic. Now, that also is why national courts are invited, and our rules of procedure of the Court of Justice of the European Union indicate that, not only to ask questions, but to suggest what, in their view, should be the union law answer. And that is very important, especially when Supreme and constitutional courts refer. I come immediately back to that with a few examples. Why is that important? Well, the only way for the Court of Justice to develop union law in compliance with the common constitutional traditions, and I would even say beyond that, the common legal traditions of the member states, even beyond the strictly constitutional realm, that is to know what national law would normally do in a similar situation. So please explain that to the Court of Justice. And you know what happens next. Every reference for a preliminary ruling which comes in the Court of Justice, for instance, from the Supreme Court or from the Constitutional Court, already 6 cases from the Latvian Constitutional Court, they are put in Latvian language. That's fantastic. But the first thing which happens, they are being translated. All your judgments, entirely translated in all 23 other languages of the European Union. So in fact, you take the initiative for the triggering of a pan-European debate on the legal issue of union law. When the referring court, the Constitutional Court or the Supreme Court, can also be a lower instance court, but of course, the Supreme Court and the Constitutional Court sitting in last instance when there is a question of union law arising, which is a debated question, they are obliged to refer. That is the 3rd paragraph of Article 267. So they refer when they bring to bear their own views. All the other member states can react to that position taken. It leads to a well-balanced debate all over Europe, and finally to an outcome of our judgment which will integrate all these inputs. Now, this brings me to my second remark, and I've adapted my prepared speech because I find it more fruitful to directly react to several things said by the previous speakers. And that is, this dialogue is a dialogue directly between the Court of Justice of the European Union and the National Court asking the question. Chief Justice Strupic started out with a case where the Supreme Court asked made a preliminary reference to the Court of Justice. The Court of Justice gave an answer interpreting union law, and that answer, he said, led to the fact that some rules of national law were incompatible with union law. And now it comes. Then he said, we then referred the matter to the Constitutional Court for that court to have the national law set aside, and then it was all okay for us to give the primacy precedence to European Union law. With respect, the outcome of that case is of course correct, but I draw your attention to the Simmental case. The Simmental case is a case of 1978, which has been developed, so it's 45 years old almost, which has been developed in a constant case law of our court. It must be the competence in the national system of the court which has asked the question to set aside, that is to disapply, the national law which is in conflict with union law. But of course, Chief Justice Strupic is wholly correct that that does not sort of annul, quote unquote, the national law. That can only be done by the parliament or by the Constitutional Court. That is what the Germans call Verwerfungsmonopol. So that is the system. But in the case pending, in the actual case, the Supreme Court should not be obliged to first refer the matter to the Constitutional Court. It can refuse to apply the national law directly implementing the judgment of the Court of Justice. That is a cimental line of cases which you find explained in every textbook on EU law as sort of one of the main things, just like the primacy, the uniformity, etc. And the reason for that is precisely that the effectiveness and the primacy of union law must be guaranteed. And then you can ask yourself, and it's important to underline that in an open dialogue between colleagues, sharing this common responsibility for the fundamental values of a rule of law governance system, which we know in the European Union at both union level and at national level. And that is this. The primacy of union law has nothing to see with sort of a subordination, so a strict hierarchy. It is something very modest, finally. It is meant to have the common character of the rules of union law preserved. Why? It's very simple. It's the essence of the European Union. Member states have decided to confer on the Union a whole range of competences in policy areas where the member states, each one for themselves, could not sufficiently deal with these policy matters effectively. All right. That is in fact a paraphrase of the subsidiarity principle. Clean air, clean water, fight against climate change, internal market, common currency, asylum and immigration, an open space without internal frontiers, Schengen. All of this requires common rules. Consumer protection for goods manufactured in one member state, commercially processed through several other member states. Rules on product liability, consumer protection needs to be uniform. All right. So the legislative apparatus of the European Union in co-decision between the Council and the European Parliament makes a whole range of common rules. Those rules need to remain common in their interpretation, application, and enforcement for a very simple reason. Member states are equal before union law, and the citizens of member states are equal before union law. So when the European Union acts within the realm of within the reach of its conferred competences, the rules the Union makes must remain common as to their interpretation, application, and enforcement in order to guarantee the equality before union law. And this brings me to a next point in the speech, this time of Vice President Lavings. That is this whole matter about the place of secondary EU law and the hierarchy of norms. I understand the questions. And since my good colleague Lavings had sent his questions before, for which I thank him expressly, I have been able to reflect a bit on the matter. I think that with respect, the distinction between primary union law and secondary union law is ill-founded. Union law is a whole, is a single set of norms. And it is true, like Chief Justice Strupic said, there is not in the treaties a clear hierarchy of norms. The TFEU describes a whole, Article 288, a whole range of types of legal rules, but there is no clear hierarchy. Although, since the Lisbon Treaty, it must be said, there is something which nevertheless comes relatively close to it. You have the legislative acts, you have the delegated acts, you have the implementing acts, which I personally, and also the Court's case law, Court of Justice's case law, sees as a hierarchy in that order. But it is true that the legislative acts, the delegated acts, and the implementing acts can take the form of regulations, directives, decisions, and so on. So you can't readily recognize the type of act. So you have to see through which decision-making process the act has been adopted to find some sort of a hierarchy. But for purposes of our debate today, that is not all that important. Why? All the acts of the Union institutions have been made in compliance with the treaties. And you see this in several of the examples which have been quoted. Almost all of them. Chief Justice Strupisch referred to the Schecke and Eifert case, with their first names Marcus und Volker Schecke und Eifert. I was the reporting judge in that case more than 10 years ago. And it's a good example, you're absolutely right, saying, well, there, regulations on the common agricultural policy and subsidies, both regulations of the Council and of the Commission, you said were assessed in the light of a directive. Well, it's a good example. What does it mean? The directive, it was the Data Protection Directive, the predecessor of the GDPR, the present General Data Protection Regulation. But of course, what did we do in that case? We interpreted the directive in the light of Articles 7 and 8 of the Charter of Fundamental Rights of the European Union. In other words, what you might say, this is all secondary law, in fact, the secondary law is constantly interpreted in compliance with primary law, both the treaty provisions and especially the Charter of Fundamental Rights of the European Union, like you would do it in Latvia. All the legislation and executive instruments will be interpreted in the light of compliance with the Constitution. So that is here the same for European Union law. The Tarico MASMB case, it is, of course, on decisions on the VAT, legislation, on the VAT, but it is also encrusted, and you refer to it in Article 325 of the TFEU. It is also referring to Article 49 of the Charter, that is the principle nulla poena sine lege, so no sanction without the law, no crime without the law. So it is always encrusted in the primary law. So the distinction between secondary law and primary law is not fruitful. And I give you, in order to illustrate that and also to respond to a number of the questions of Vice President Lovings, I'm going to quote you two cases. And the first one I start with is the Meloni case, because Vice President Loving said, all that is being done in terms of applying legal rules in Latvia needs to comply with the fundamental rights of the Latvian Constitution, and this cannot be influenced by EU secondary law. And he referred to the Bundesverfassungsgericht saying they also think like that. Well, I want to reply to this, both in terms of our case law and in terms of the recent case law of the Bundesverfassungsgericht precisely. And I do this with the help of two cases, the Meloni case of 2013 and the Cohen case, in essence. So first of all, Meloni. It shows you how secondary law and primary law is wholly integrated. In Meloni, it is an Italian businessman who was convicted at first instance, confirmed on appeal, and finally confirmed by the Corte Suprema di Cassazione in Italy, so all three instances, for fraudulent bankruptcy. Few days before the final judgment ruling against him of the Corte Suprema di Cassazione, he goes to Spain. Now, at each level, he was convocated for the hearing, so he knew the place and the time of the hearing, and he was represented by a lawyer of his trust, a lawyer whom he had mandated. Now, Secondary union law. There is the framework decision on the European arrest warrant, initially adopted in 2002, amended in 2009. And it says that when a person is being convicted while not being personally present at the hearing, the proceedings, but the person knew the place and the time sufficiently in advance to defend himself and to choose to be present, and was additionally represented by a lawyer of his trust, the person must be deemed to have voluntarily and unambiguously surrendered his right to be personally present. Therefore, there is no breach of the right of defense. The person must be surrendered. So, against that background of a secondary law act, but putting into effect the rights of defense in criminal proceedings of Article 48 of the Charter, the matter develops as follows. Meloni has fled for many years now to Spain. The Italian judicial authority issues a European arrest warrant. The ordinary courts in Spain, first instance and appeal, Tribunal Supremo, they all order the surrender of Meloni to Italy in compliance with the framework decision on the European arrest warrant, saying he has unequivocally and unambiguously surrendered his right to be personally present, no breach of the rights of defense. Then there is a final appeal, similar to the Verfassungsbeschwerde before the Bundesverfassungsgericht against a judgment of the Supreme Court. In Spain, it's called the Recurso de Amparo, before the Constitutional Court in Spain. And they have a provision in their constitution saying that when you have not been present at the criminal proceedings in which you were convicted in absentia, even though you were represented by a lawyer of your trust, that you have in any event the right to a retrial. So the Spanish Constitutional Court asked first, like Mr. Levings was explaining, what is the precise meaning of the framework decision? Can I, in compliance with the framework decision, that is the act of secondary EU law, impose as a condition for the surrender the retrial? So that's a matter of interpretation of the secondary law, a beautiful example where the Spanish Constitutional Court first needed to know what is the exact interpretation of secondary EU law. The second question was, if the interpretation is, which it finally was, as you know, that the Spanish judicial authority executing the European arrest warrant could not condition the surrender of Mr. Meloni to Italy to a retrial, is that reading of that secondary law compatible with the Charter of Fundamental Rights of the European Union? So it's a national constitutional court to ask the Court of Justice with the second question to exercise constitutionality control in light of the Charter of Fundamental Rights of the European Union, which is our common Bill of Rights to all 27 member states. And they said, if you consider it to be compliant, which, by the way, we said it was compliant, we referred extensively to the case law of the Strasbourg Human Rights Court, and the opinion of the Advocate General also goes into the Constitutional Court's case law of most of our member states. So the constitutional traditions common to the member states, as well as the human rights case law in Strasbourg, made that this was indeed compatible with the Charter, with the common European standard. And then in that context rose the third question: can we still make our constitutional interpretation, which is so-called more protective for the defendant, prevail as a sort of matter of national identity? There, of course, the court said no. But why did the court say no? The court said no, our court, because the matter had been fully harmonized at European level. Why? As you know, the European arrest warrant is a matter of mutual recognition. And the mutual recognition rests on reciprocity. So it means that if the Spanish can put their own conditions, then the Latvians can put their own conditions, the Belgians can put their own conditions, and the whole matter falters apart. So in other words, the choice which has been made at European level in making the secondary law rule of mutual recognition conditional upon the fact that the person convicted knew the place and the time of the proceedings and was represented by a lawyer of his or her trust, the cumulative presence of these conditions was a sufficient guarantee of the rights of defense because the person had a choice to be present. Not having exercised that choice, it's a voluntary and an unambiguous decision on his or her part to be absent. So, what this case teaches us is that, in fact, the place which remains for the national fundamental rights is dependent on the question whether European Union law has fully determined, within, of course, the competences conferred on the Union, has fully determined a particular field of the law, like in this case, the mutual recognition principle in the framework of the European arrest warrant system, or has not. If the answer is it has not, if European Union law has only minimally regulated the number of things, leaving a huge margin to the member states to exercise their own choice, then we are exactly, and Chief Justice Strupisch referred to it, in the Tarico MASMB saga, where the only thing which Article 325 TFEU and the value-added tax directive says is that the member states must have effective, proportionate and deterrent sanctions. Final stop. The whole sanction regime is national choice. This is definition of shared competences. All that the Union has not regulated remains in the competence of the member states. That is why we said in the MASMB case of December 2017, the prescription time, statute of limitations, for criminally prosecuting grave fraud in the value-added tax system has not been harmonized. Every member state can therefore make its own choice as to prescription time limits for criminal prosecution and can characterize them as either being procedural or substantive law matter. It's national constitutional choice. So you see in the contrast between these two cases, that is Meloni, where the Union legislator, because of the subject matter to be legislated on, had up till the detail determined what the member state needed to do, as opposed to subject matters where the Union, either for lack of competence or for lack of political will to exercise to the full extent the competence which has been conferred on the Union, leaves the matter largely to the member states. Then the member states apply their own constitutional standards. Now, this is exactly what the Bundesverfassungsgericht did in the Recht auf Vergessen 1 und 2, the right to be forgotten 1 and 2, of the 6th of November 2019. And I had last week, exactly in this same setting, a digital conference at the College of Europe in Bruges with President Stefan Harbart. And we discussed extensively this. And it's now absolutely settled. And in your next meeting with the Bundesverfassungsgericht, President Harbart will explain that to you. Like he explains it all over Europe when he gives conferences. The Bundesverfassungsgericht now has embraced and integrated Meloni in its case law, fully. They said that when European Union law has fully determined a subject matter, thereby no longer leaving legislative choice, room for legislative choice to the member states, it is for the national constitutional courts to apply not their national constitutional fundamental rights, but the fundamental rights as they are laid down in the Charter of Fundamental Rights of the European Union. In that case, it was about the General Data Protection Regulation, GDPR. That is, as you know, a fully nitty-gritty detailed regulation till the last finesse, an act of secondary law, to be interpreted fully in light of Articles 7 and 8 of the Charter, but also 11, the right of freedom of expression and information and other fundamental rights. All secondary union law must always be interpreted in compliance with the primary law. And what does the Bundesverfassungsrecht say? It says that the fundamental rights of the Grundgesetz, of the German Constitution, must remain out of application, cannot be applied, they say it in so many words, because of the Anwendungsvorrang, that is the primacy of application of European Union law, including the Charter of Fundamental Rights of the European Union. So the German Constitutional Court accepted that its constitutional competence, and Vice President Laving spoke about competence, that its competence under the Bundesverfassungsgericht Gesetz now for matters which have been fully determined by the secondary law of the Union, not leaving any margin of assessment or appraisal to the member states, should be controlled by the Bundesverfassungsgericht on their compliance with fundamental rights, but not the fundamental rights of the German Constitution, the fundamental rights of the Charter of Fundamental Rights of the European Union, exclusively. And if there are problems of interpretation in that respect, they should ask a preliminary question in the way I started out with, contributing their own views on the matter, leading to a pan-European debate, and that's it. If union law, that is right to be forgotten, two. No margin left for the member states. In right to be forgotten, one, that is the case of Tarico MASMB or Åkerberg-Fransen. That's the case where there is a margin for the member states. Then they say we apply the national constitutional fundamental rights, but with the Charter of Fundamental Rights being a minimum, because you can never accept that the fundamental rights protection nationally would be less than the Charter. So it shows you that it's not a matter of secondary union law and primary union law. The Bundesverfassungsgericht does not make that distinction at all. It is the whole of union law, because the secondary union law is automatically interpreted in the light of the primary union law, and first and foremost in compliance with the Charter. Another beautiful example comes from the Belgian Constitutional Court, which, as you know, refers all the time cases to our court. It is the famous case of test d'achat. It is the equal treatment of women and men for premiums and benefits of life or death insurance. And there were differences made in a directive of the European Union between women as a group and men as a group. The Belgian legislation had, of course, implemented the directive and made that same distinction at the level of the Belgian law implementing the directive. The Consumer Protection Association, with a number of women and men, because it depended on the type of insurance, went to the Constitutional Court and said the Belgian law implementing that directive is against the equal treatment rule between women and men. What happened next? The Constitutional Court referred to the Court of Justice, Belgian Constitutional Court asked for the interpretation of the directive, and in case the directive really was to be interpreted as it looked like, whether it was valid, adding that the Constitutional Court of Belgium, for the reasons explained, considered that the directive, in that provision at least, was invalid, because contrary to the individual equality between women and men. A pan-European debate, more than 10 member states came in to let their light shine on the reasoning of the Belgian Constitutional Court criticizing the compliance of that directive with the equal treatment of women and men laid down in Article 23 of the Charter of Fundamental Rights of the European Union, the Court of Justice invalidated, which means annulled, the provision of the directive, as a consequence of which the National Constitutional Court of Belgium annulled the law which had transposed that directive. So it happens all the time like this. So the secondary union law, you should leave that out of your reference frame. And the last element, there are many more things to say, but that will be then for the further debate. The last element I want to stress is the Cohen case, the Cohen case of 2008, because it sort of draws together all what I've been saying so far. Cohen is a Romanian national who was a migrant worker in Belgium. So he come from Romania to Belgium, and he worked there for quite a number of years as a migrant worker, protected by the free movement of workers provisions of the Treaty on the Functioning of the European Union. He is a homosexual man, lives in Belgium with his partner, a US-American citizen. And as authorized under Belgian law, they marry in the Hotel de Ville of Brussels. They're now a married couple. When the contract of Mr. Cohen as a migrant worker in Belgium was finished, he returns to his member state of origin, Romania, to continue his career there. But the Romanian authorities refuse to give an authorization of residence to this US national. They refuse to recognize that this man is the spouse of Mr. Cohen. And here, European Union law comes in. Why? There is, as you know, the directive, I would say with Chief Justice Rupiš, a legislative act, because adopted by the Council and the European Parliament, on the right of Union citizens to free movement across state lines within the European Union. Free movement. And it says that the free movement attaches to the Union citizen, as well as to the members of the family. The first member of the family being quoted is the spouse. But it stands there, just like I'm saying it here. The spouse, final stop. If you go look in the preparatory works of that directive, you see that an extensive debate, especially in the European Parliament, developed, saying, what is a spouse? Some wanted to add, irrespective of their sex or some of their gender, something like that. But there was no agreement. And at one point they say, this is as good as it gets. We simply say spouse without anything more, not defining the term. If it's a problem, it will be for the Court of Justice, not a Court of Justice out of the blue, but a Court of Justice in interaction with national courts. And here, this is what happened. Mr. Cohen attacked the refusal of the residence permit for his spouse, a man, US national, before the courts in Romania. And the matter is finally referred, like it could be done in Latvia, by the Supreme Court to the Constitutional Court. Why? Because, and it's all to the credit of the Supreme Court of Romania, they said, well, but this man, he is married to a man, but there is case law also of the Strasbourg Human Rights Court that this is maybe protected by family life, and family life is protected by the Romanian constitution. True, we don't know homosexual marriage in Romania, but we do protect family life. And moreover, there is also the provision in the Romanian constitution, like in the Latvian constitution, that EU law prevails over national law. And so we need to know what EU law means. So it is the Constitutional Court of Romania, much to its credit, just like Meloni is the credit to the Spanish Constitutional Court, and Testacha, a major case, which I quoted, the Belgian sex equality case, is a major progress of equal treatment of women and men to the credit of the Belgian Constitutional Court. So you see all these examples of constitutional courts making major progresses of European Union law where they can bring their views to bear on the European Union at large. And what does the Constitutional Court say on Romania? Romanian Constitution, in its order for reference, they say, well, we don't have homosexual marriage in Romania, that's clear. The civil code in Romania says that it is the union between a man and a woman. But we do protect family life, and there is primacy of union law over national law. So we want to know what is the state of play of union law? What is a spouse? So although family law is a national law matter, which we respect, that's the principle of conferral, the competence for family law has not been conferred to the Court of Justice. We, however, must interpret the rules on free movement. And since the rules on free movement include the family members as defined in the Directive 2004/38, we have interpreted that rule. And we have said that for the purposes of that directive, the term is to be defined by the member state where the marriage is lawfully concluded. And the other member states must recognize the effect of such a marriage in their national legal order to the sole extent, to the limited extent of the proper application of the rules of European Union law, in this case, the free movement rules. To say it in very practical terms, Mr. Hamilton, the spouse of Mr. Cohen, needed to receive the residence permit. After our ruling, the Constitutional Court of Romania has annulled the decision refusing the residence permit. So the case has been perfectly solved in compliance with union law. But we were very, very cautious. Why? We know that family law is national law. So we underscored in our judgment that the question to know whether there is homosexual marriage, same-sex marriage or not, is for each member state to decide. So we did not go as far as the United States Supreme Court in the very similar Obergefell against Ohio case, a case decided in June 2015, where I would say Belgium in the story is Maryland, and Romania in the story is Ohio. There it's a same-sex marriage between two women concluded in Maryland, which Ohio refused to recognize. The case reaches the United States Supreme Court, and there the United States Supreme Court, 5-4, decides that Ohio must recognize the marriage lawfully concluded in Maryland, full faith and credit clause, it's the same solution than in our Cohen case. But second, that all the 50 states of the American Union need to introduce same-sex marriage, because otherwise there would be unequal treatment. The Court of Justice of the European Union deliberately did not take that second step. It's important to see that. We did not take the second step, obliging all the member states to introduce same-sex marriage. Why not? Because that would be a deep encroachment on national competence, which it is for each member state to make the choice. And then you will say, yes, but there might be unequal treatment because you have now these two men in Romania who are married, and the others are Romanian homosexual couples, they cannot marry. Yes, but from the viewpoint of European Union law, that is a fundamental distinction. That is, the Cohen-Hamilton couple has been lawfully married in Belgium at a moment in time when they were, at a point in time when they were exercising their EU free movement rights. And the free movement right contains the right to go out, but also the right to come back with full respect for your family life. And by the way, we quoted, of course, Article 7 of the Charter of Fundamental Rights of the European Union in the Cohen case, saying that this was needed for the protection of family life. That is the only thing which European Union law settles. Suppose there were now to come a further case of a Romanian homosexual couple which says we never left Romania and we also want to marry. That will be for the Romanian Constitutional Court to decide. It is solely a matter of Romanian law. Think about right to be forgotten 1 and 2. It's clearly right to be forgotten 1. It's a competence which the European Union has not, therefore consequently has not exercised. It is solely a matter of fundamental rights of the national constitution. So you see, that is really the picture I think you should see. But this Cohen story shows that it is really unhelpful to make the distinction between secondary law and primary law of the Union, because the directive is a directive to implement free movement rights. And free movement rights in the European Union legal space, without internal frontiers, Schengen zone, that is the core essence of the primary law of the European Union, right? So this whole Cohen case interprets the directive in the light of the free movement provisions of the Treaty on the Functioning of the European Union, and in the light of Article 7 of the Charter of Fundamental Rights, the protection of family life. So where is the distinction between secondary law and primary law? It is not there. So I think it's very important that you do what needs to be done. If this case had played vis-à-vis Latvia, you should be able to do the same. That is, annul the refusal of the residence permit for the spouse man. If thereafter there are problems for social security, equal treatment, or for whatever, that is purely a matter of Latvian constitutional law. But you should draw directly the consequences. That is the Simmental case law of 1978. This is a little bit what I wanted to say anyway, but I have tried to respond to as many of the excellent points raised, really, I mean this, by Vice President Lavings and Chief Justice Sturridge. But of course, I remain totally available for further debate. Thank you very much, and excuse me that I've been a bit too long, but it's so interesting what you raise that we should not forgive ourselves not to have reacted, because you are entitled to get a reaction on all of this. Thank you very much.
Thank you very much, President Leonards, for your long 15 minutes. It was very interesting, thank you. And now I would like to give the floor to the Judge of the Court of Justice of the European Union, Professor Ineta Ziemele. Please, floor is yours.
Yes, thank you very much. And well, by now, probably good afternoon already in Latvia to everybody. I would like to thank the Constitutional Court and the Presidency of the Constitutional Court and the staff members of the Constitutional Court for putting us together on the issues that are of, I would say, very great importance in Europe. As President Leonards was talking, I was trying to cut my speech so that we would have much more time for debate. So I'm hoping not to take too much of your time as far as my presentation is concerned, and to leave us time for questions and answers. And in fact, I do have to say that I'm grateful to all of the previous speakers, because the issues were already put on the table. And I'm kind of in a position of rounding it all up. Now, first of all, I would not underestimate. There is a difficulty. There is a difficulty, a delicate relationship between the constitutional courts and the Court of Justice. And I have noticed that this delicacy is sort of, coming and going a little bit over the years. One particular period in history was the moment of the entry into force of the Lisbon Treaty, which generated practically all of the constitutional courts have their Lisbon Treaty case law, where the constitutional courts, as we know, actually gave a renaissance to the constitutional identity control. And that, I think we have to keep that in mind. It is part of our discussion. And the reason for that is we are in a 21st century, but many things that came up today, what we had were the concepts, the ideas that have created us, the way we look at law today. What we had today, we had the sovereignty of the state, we had the supremacy of the law of the land, we had the issues of legitimacy. These are all of the ideas, the principles that shape us as lawyers. And so these ideas, the hierarchy of legal norms. And so we are still stuck within the 19th century, and our debate is a little bit, in fact, stolen by the way we are taught in the law schools. That already came up. Now, I think we have to put that on the table and we have to deal with that. I'm not going to go more into this. I meant to have more on this, but let it be for the time being, just so that we know we are captured, we are kidnapped still today by the ideas on the way we organize our societies that are already at least 200 years old, if not more. Now, what the Court of Justice has done and the Treaty on European Union has done, and I would like to guide you to Article 19, point 1, second sentence. And in that sentence, and it's been already mentioned today, and I would like to point it out, underline it. It is so in accordance with the EU law that each member state has an obligation to create an effective system of remedies for the implementation of the EU law. And indeed, for the purposes of in Latvia, that effective system is created by the court system and the Constitutional Court. Now, there has been a very interesting development of the case law, whereby the Court of Justice interpreted Article 19 of the Treaty on European Union. And I would like to simply give you the cases. It's the case of the Portuguese Judicial Judges Association, case C 6416, that we know also in Latvia. And our current president, the former judge of the Court of Justice, was the judge rapporteur in this case. Now, that case actually kind of opened a possibility for the next line of case law in the Court of Justice that has to do with the situation in Poland that affects the Polish judiciary. And I would like to refer you to the joint cases C 585 18, C 624 18, etc., because these are the cases very important to look at. Of course, they are available naturally in Latvian too. But in the joint cases, Polish cases, the Court of Justice said the following. It said that where the institutions that have to apply EU law do not comply with the requirements of independence, where that law, which regulates the domestic remedy, is not in compliance with the rule of law, that law has to be set aside. So we are talking about national law, which does not provide for the independence of judiciary in this case, And that national law, therefore, is the bar for full effective implementation of EU law. And therefore, that national law has to be set aside. Now, the question here is, it has come already in the discussion, who sets aside the national law? And that is very important. I would say, off the top of my head, in Latvia, that would be the parliament, sure, but also the constitutional court, if the case arises. So you have the synergy here, where, from the point of view of EU law, the Court of Justice has been, in fact, helpful in this case, strengthening the independence of the Polish judiciary, but also probably in some contexts, setting a task to the national system. Well, you should, set aside the national provisions that disturb the implementation of a number of important principles that are common to the European legal space. There, of course, the question is whether the Parliament will be willing to do so and whether the Constitutional Court will be willing to do so. That can be tricky in some circumstances. But so this synergy where the EU law helps also the effectiveness of the domestic remedies, I really would like to underline it. I can't underline it more, how important it is, also in the Latvian context. What we see here is we're not alone. I mean, we have our responsibilities in Latvia as far as the common European legal space is concerned, but we are not alone in it. It is, I think, this collegiality between the domestic courts and the Court of Justice that is extremely important, that is possible, and that has played out already in this context. Now, the main point I'm going to make now concerns the issues raised by Vice President Laviņš and touched upon, but the Supreme Court is really not in this challenging situation. The difficulty that the Constitutional Court has is that, of course, it has to uphold the law of the land and its supremacy. And it is mandated, it is legitimated to do that, and all of these important concepts coming from the 19th century that we still live with. Now, what should the Constitutional Court really do within the context of the European Union law? Now, in Latvia, and true, the hierarchy of legal norms, and true as far as EU law is concerned, the President Leonards explained it beautifully, the hierarchy becomes irrelevant as far as EU law is concerned. But from the constitutional perspective, it is relevant. Now, you see, we need to find a solution to this to begin with, unless we give up with few ideas that we are living within still today. Now, as far as Latvia is concerned, Article 68 of the Constitution is of key importance. And it has been said since actually even before Latvia joined the European Union, that within Article 68, it's a very crowded reception place. If you imagine an office of a secretary, for example, to your office, it's a very crowded article. Because Article 68 is a reception area of the whole EU law in Latvia. The legislator never meant that we would not comply with the EU law as explained by the Court of Justice. And that is all that understanding is at the constitutional level. It is constitutional principle. And furthermore, of course, Latvia is a monist country, and we apply from different sources of law, also those outside our jurisdiction. We apply directly applicable rules directly, for example, regulations, not to mention the EU treaties or any other treaty Latvia has ratified. In practical terms, what does it mean to apply directly regulations? In fact, if it is helpful, I will add a few things to what President Leonards just said. I mean, the first principle I would go about is the principle of harmonious interpretation, of the provision of the Constitution and the relevant applicable EU rule. But mind you, harmonious interpretation only goes, and that's the explanation of the Court of Justice, it only goes for as far, because we cannot, as judges, interpret any of the rules contra legem. That's the stop. If you cannot open up the provision of the Constitution, because it really goes against the very idea of that provision, that's where the real difficulty arises. Now, there is no difficulty to set aside the domestic law, because that's what the Constitutional Court is for. If the inspiration comes because of the application of EU law, fine, because we generally, Article 68 has said it's already part of the Constitution. However, if it is contrary to the constitutional provision, and it is in this context that National Bill of Rights indeed comes into play, and also the Fundamental Rights Charter. And we have several actions, actions that we need to do parallelly. In fact, first, we have to interpret the regulation. The Constitutional Court, like the Supreme Court and the other courts, are the first ones, I emphasize, the first ones to read the relevant applicable EU law, the first ones. Then, of course, we are applying the Constitution or the law as it may be. However, and I will give you in the end, hopefully, one reference, very important. Of course, we have to read the EU law in accordance with the methods of interpretation developed by the Court of Justice, where there are slight differences, especially when it comes to the Fundamental Rights Charter, the reason the Fundamental Rights Charter has been drafted. And so these methods of interpretation of the Court of Justice, indeed, they have to be taught. They have to be taught, and we have to learn them and see, where with these sort of dimensions, different roads, parallel roads of interpretation with regard to national or European rules, how that sort of meets at some point down the road. Now, in the regulation, what is important when we apply the still secondary rule, quote unquote, what is important is to establish subjective right. It is important from a constitutional perspective to find whether directly applicable EU law provides for a subjective right, which for some reason, some authorities before the Constitutional Court have not seen, have misconceived, etc. And so the final guarantee of the proper application of EU law is the Constitutional Court, because it is the Constitutional Court that at the national level, as a final call, can identify and should identify that subjective right that the primary or secondary law, EU law, might really provide for to the legal or private persons in Latvia. And that subjective right is within the method of harmonious interpretation between the two legal systems. Now, so you may ask the question, but then the Constitutional Court will be accused of legislating. The answer is no. And the reason why is because the government and the parliament in Latvian case has already participated in the legislative process at the level of the European Union, Commission and the Council, and the Latvia had all of the chance in the world to fight for that particular provision or against in that regulation. So the Constitutional Court can under no circumstances be criticized, and that would be a very cheap criticism, be criticized for having understood what subjective right stems from the EU law and for having harmoniously interpreted the Constitution with that subjective right. Now, of course, when it comes to directives, it's much more complicated because directives have no horizontal effect. but they are being transposed as far as the objectives of the directives are concerned. What I would like to say is the following. What I see sort of stemming out of especially recent case law of the Court of Justice, I found the case A, Veselības ministrija, the one that was referred to by the Supreme Court, and very well done. It's a beautiful reference in an area which is not harmonized, which is really very complex. It's transboundary effect of common European legal space, but it's not an evident case. And this is why I think that case, for the time being, sets an outer limit as to how far EU law is relevant and affects such decisions in the areas where there hasn't been a harmonization set. This is why I would say what has been decided by the Court of Justice in that case is of importance. And what the court did not say, yes, there is a subjective right that stems even not from the regulation, but also not from the directive, when it comes to the person simply wanting to have that medical service in Poland. The court did not say that. These regulations, this regulation or directive does not provide for such a subjective right. But, and that's a very important but for the Constitutional Court, the court said, but there is a subjective right of not being discriminated on the basis of religious beliefs. Because prohibition of discrimination and equal rights in the Charter, in fact, what I say is of a particular importance given the whole history of evolution of the EU law. It's an imperative principle. That's what the court has said, equal rights. And so through Article 91 of the Latvian Constitution and through the common European principle on equality of rights, there we do have quite a number of possible subjective rights that, are to be conceptualized as the case may be in front of the court. And that's an area where one has to be very careful. And there I would have thought that, by the way, equally, if the Supreme Court came to the Constitutional Court with the equal rights problem because of the religious belief, in fact, I'm pretty sure the Constitutional Court of Latvia would have said, but this is a question of equal rights. You see, so you may not have even needed to go in this case where that's not a harmonized area of law. You may not have needed to go to the Court of Justice, but in terms of fundamental rights, the fundamental rights sort of issue here is rather, to my mind, rather evident. Now, I would like so 2 points in concluding the. 2 cases that the Constitutional Court of Latvia has decided previously that, to my mind, are a very good point where Constitutional Court is right now, but now with the benefit of hindsight, actually, looking back and having a nostalgia of my years in the Constitutional Court, sort of looking back at some of the judgments, sort of better ideas come up. Now, in the those are the cases VTA case that was judge rapporteur was President Osipova, and the property tax of Riga municipality where the judge rapporteur was Justice Kusiņš. These 2 cases actually of the Constitutional Court are a very good sample of trying to put together all of these sides with different ideas that stand behind the EU as such, and the national constitutional order as such, and how that could be sort of fixed together. And just to remind you, in the VAT case, this is exactly what the Latvian Constitutional Court did. Within Article 105 on the right to property, what the court did, it actually took out of the VAT directive a subjective right. And in fact, it could do so because of the extensive jurisprudence, naturally, of the Court of Justice. In that judgment, the court refers to that jurisprudence on VAT. That's when overpaid VAT tax is not returned to the person who has paid VAT. So the question was, within what period of time it is sort of reasonable, not to return and then to return that tax. A, court considered it is a question of right to property within a national Bill of Rights. And B, looking at different sort of how the Court of Justice juggled with the time periods, the Constitutional Court said it reasonable that, there is a return of overpaid tax after six months or whatever the period was. But the court clearly, Constitutional Court, read all of that EU law part as into a subjective right, a concretized Article 105. And another one, even a more beautiful example, because I love Treaty on European Union and especially Article on European citizenship. We, at the time, in Justice Kustin's case, we had to apply Article 91 of Equal Rights. And there, for the first time, the Constitutional Court had the possibility to concretize the prohibited grounds of discrimination and to say that difference in indexing of property tax, which is based on citizenship, and in this case, Latvian residents had one sort of set of indexing, and the other EU citizens from other countries were not submitted to the same treatment, to the same regime as Latvian citizens. So we had to say that that is a distinction and based on EU citizenship. And there should not be a distinction based among EU citizens. So again, this is an example of a subjective right not to be discriminated among EU citizens. And that was read already into the Latvian constitution. Now, again, that was done by, of course, first reading the available EU law and the case law of the Court of Justice. So, I'm not going to talk about, of course, constitutional identity as being kind of that we will hopefully discuss in September. It's really something that one has to discuss for 3 days, if not more. Here, it was more sort of in terms of how constitution is being enriched and what the Constitutional Court really does in practice with the different sources of law. And to, in fact, conclude, whether a Constitutional Court can set aside domestic law if it is contrary to EU law. Yes, especially if it is it will be within the Constitution, and hopefully it complies with the constitutional identity. Of course, constitutional identity has to be verified ex officio all the time. That's just what the constitutional courts are for. But I have a difficult time, I've written about it, I have a difficult time to see that there would be sort of major discrepancies when it comes to main principles, main values on the basis of which all of us within the common European legal space we function. In Latvia, there are two particularities. I can mention them quickly. That's the doctrine of state continuity and Latvian language. This is the core of Latvian constitutional identity. And there we have some case law which on European level looks maybe something interesting. It is interesting because it's particular. And that's linked to these two main principles of our constitutional identity. And this, of course, has to be each time verified. Maybe these do come in, these principles, into a case. So we will continue discussing that, who sets, of course, what aside and why. I think that's the main question, given our respective responsibilities. But to conclude, I would like to emphasize the following messages that I would like to pass on. Now, it is extremely important not to be afraid and to engage with the rules of European Union law. Why? Because in Latvia, clearly it is part of the law of the land. Now, it requires, and here I really come back to the point raised by Chief Justice, I could not support more. It really requires changing the way we teach law at national universities. And it requires to change the approach to continuing education of legal professionals. We cannot maintain separate, narrow, national legal sort of areas, legal domains. There isn't anymore so narrow and so national within our legal sort of space. I should hope we could be able to integrate, common space of security and justice within criminal law. I should hope we are able to integrate, VIT directive, etc., within commercial law, etc. Now, there has been so much change in law that calling something national, civil, criminal, becomes really, I must say, complicated, even constitutional. I am not afraid to say that. So that really needs to be done. And I think Latvia is sufficiently, we can do it. So we are a very compact state. We can do it. Now, then I would say there are two outstanding tasks at the European level. The problems will come up in the field of fundamental rights. That's because we do have three main actors that are not yet very well united. The court in Strasbourg, the court in Luxembourg, national constitutional courts. That architecture is far too divided. And there is a need for a political engagement, of course, and we really have to solve that problem because, as Chief Justice said, it's far too complicated to have these three structures kind of promoting their own, at the moment of the time, their own understanding of what equal rights is, or et cetera, et cetera. So, but that's a first, and it's truly a problem, European human rights architecture. And secondly, I would really say, with very due respect to President Leonards, and maybe we could do something about it. These synergies between constitutional courts, in particular, because with the Supreme Courts that functions well, but between constitutional courts, in view of their particular position, historically too. With the constitutional courts, I believe there is a need for a more sort of formalized, more structured, not just informal dialogue, but more formal dialogue. We need the contributions of the constitutional courts more and more because the EU legal order is becoming more consolidated and has become constitutional actually in nature. And there is a beautiful citation, Doctrine in the End, that I would like to provide you with, and I have few pieces of literature I would like to also give to the colleagues, but the quotation is the following. So the author says that justified challenges by constitutional courts can point to defects and trigger necessary reactions on the EU level. This is why it's important the constitutional courts truly engage with EU law. Cross-fertilizing relationship between the Court of Justice and national constitutional courts is the cornerstone and driving force of the European integration project. And I cannot agree more. And we really have to do quite a number of steps actually to implement this. And finally, in the end, two pieces of literature I would genuinely recommend. I mean, the first one is, it is in French, but hopefully maybe we could even translate it into Latvian. But I really appreciate it has come out because I've been struggling with this to have more clear methodology myself. And that's the book that recently appeared by the president of the Court of Justice, Professor Leonards. and another contributor, Mr. Gauthier Fons, on the methods of interpretation of the Court of Justice, les méthodes d'interprétation de la Cour de Justice. Now, this is the book. It's extremely, you can, like Latvia, you can conceptualize it very quickly, and it is truly something that all national judges, as a tool, I would say, to be able to do that first read of EU law that we need to apply as national judges, this book is absolutely brilliant. And another one on constitutional identity, there is a lot of writings and books, and that's why I did not even stop with that. But however, Common Market Law Review, number 57, 2020, contains, in my mind, sort of the articles that already are forward-looking on this debate where we have been stuck a little bit in the past. But of course, it does invite to these synergies from a horizontal sort of perspective. In a way, we're all in it together on equal footing. Now, with these, I had slides prepared in Latvian with all of the relevant case law and the citations. However, technologies are failing me also here on this side. I did not let the slideshow go, but the advisor to the president of the Latvian Constitutional Court, Ingus Kalniņš, has these slides, and I'm sure they can be just freely distributed. They also will include the 2 final references of the relevant doctrine that I think would be very helpful. I do apologize. I was really trying to run through all my notes. Thank you very much.
Thank you very much, Madam Ziemele. We are really out of time limits, but these questions are so important to discuss that I would like to open the discussion and give us half an hour for the discussion. And now I ask everyone that has joined the webinar in the Zoom platform, you may comment or ask any questions. Please only raise your yellow hand. I don't see, but I suppose that Judge Briede from Supreme Court, please.
Yes, thank you very much. So it was very, very interesting for me also as a judge of Department of Administrative Cases to listen to all this, and I would like to say is that European Union law is very, very often subject in our cases. Almost every second case somehow is connected with the EU law, and we are not afraid to apply EU law. And the question which probably I wanted to answer is why we are going to the Court of Justice and not to the Constitutional Court. This is because usually there is no such as constitutionality or such a contradiction between our law and EU law, but we just want to make sure this interpretation, whether, because we usually have 2 parts. One is saying this EU law should be interpreted in such a way. Other party is saying no, this is shall be interpreted quite different. And we want to make sure, if we don't, of course, sometimes we see already this answer and there's acte clair and we don't go anywhere, we just answer that in fact we don't see any contradiction. But sometimes we have doubts, and therefore, because interpretation of those provisions are competent in the competence of Court of Justice, this is what we just want to go. And for example, this in this case, which Ines Ziemele was mentioned, yes, maybe we also could go to the Constitutional Court, but we are very happy to get this interpretation and this view from EU law. And probably this also will help other countries to solve similar questions. So this would be probably my answer. And Inete, I also would like to say you that already for a long time, as a professor of administrative law at the University of Latvia, we are not teaching administrative law only as national law, but also in connection with EU law. Okay, thank you very much.
Thank you, Professor Briede.
Can I knijpen?
Yeah, of course.
I might, thank you very much, President Osipova. I might react immediately. I think that what our colleague Judge Briede says is extremely important. Of course, this webinar is hosted by the Constitutional Court, and I very much appreciate this. And I can't say enough how much I'm looking forward to the live conference at the beginning of September, where we will continue this debate. I always love to come to Riga, where I was several times, but certainly for this type of meeting, because I believe, like my excellent colleague Ineta Ziemele, that we should strengthen the network of constitutional courts with the Court of Justice to develop these fundamental values, and she explained it far better than I could possibly have done so. But the first question by Judge Briede points to something crucially important. That is that 95%, if I were to make a quantitative guess, are the type of cases which Judge Briede mentions. That is, where the ordinary courts, first instance appeal, Supreme Court, that is the pouvoir judiciaire, the judiciary of the member state, totally independently from the Constitutional Court of the country, is applying union law. And her example is, let's say, a typical one. She says, I'm sitting in the administrative law chamber. There, you typically have litigation between citizens and administrative authorities, which in the end come before the administrative law chamber of the Supreme Court. In some member states, there is a separate Supreme Administrative Court. In others, it's a chamber of the single Supreme Court. In still others, you have a Conseil d'État or something of the type. Bundesverwaltungsgericht, etc. There, the first item is, and Judge Ziemele absolutely correctly referred to it, it's harmonious interpretation. In fact, the principle of what we call in our case law consistent interpretation of national law with union law is a device to avoid conflict. In other words, before you come even to a problem of primacy, you must first see, is there really a conflict? And so it is the ordinary courts, first instance appeal and the ordinary Supreme Courts, quite apart from the Constitutional Court, which inquire with the Court of Justice about the correct interpretation of union law, whether it be primary or secondary or whatever act of union law. So, for administrative courts, it's particularly important directives. And you may be astonished that I'm saying this, but directives, it was said, do not have horizontal direct effect, that is, as between private parties. However, a directive which is not correctly implemented into national law or not implemented at all, it has vertical direct effects. That is, the public authorities are bound by the directive, and there is a subjective right whenever the provision of the directive is clear, precise, and unconditional. There is a subjective right directly flowing from the directive vis-à-vis the public authorities, which is the typical setting for the administrative law courts. And so therefore, of course, you must come to the Court of Justice to know the interpretation of union law. In the case in which I've been sitting, the case has been decided by a 5-judge chamber, but you know, it's an anecdote. In this court, the president is the replacement judge whenever a judge normally sitting in a chamber is absent. So in this A case about the medical costs for the operation which was then carried out in Poland rather than in Latvia, because in Latvia it could only be done with a blood transfusion, and in Poland the same operation could be done without a blood transfusion, which was then relevant for these Jehovah's Witnesses parents who did not accept on religious grounds the blood transfusion. From my perspective, and of course we speak here openly and as friends, it was obvious that the Supreme Court had to refer. It was under an obligation to refer to the Court of Justice, because the interpretation asked was an interpretation on a regulation number 883/2004 on the coordination of social security systems. And the question was whether the refusal to give the authorization to get the son of the couple operated in Poland, whether that could be justified on religious ground under that regulation. Second, there was a directive on the mobility of patients. But again here, the litigation was vertical. It was between the parents of the child and the public authorities of Latvia, which had refused to give the authorization. So it's a vertical situation. So the subjective rights of the directive are, of course, directly effective vis-à-vis the public authorities. And then, like Judge Ziemele very correctly explained, the court interpreted both the regulation and the directive in the light of the freedom of religion, which is a charter right, and that's how it mostly happens. For us, the secondary law of the Union is consistently interpreted with the fundamental rights involved, and that was here, of course, freedom of religion. And we made the balancing in terms of sort of safeguarding the financial equilibrium of the social security system in Latvia vis-à-vis the freedom of religion. And that is a proper assessment of European Union law. And with these elements, the Supreme Court of Latvia Administrative Law Chamber has indeed all the elements to apply national law consistently with our judgment. So, in fact, in that case, a real conflict has been avoided because the national law can be consistently applied. But that must be done by each one of the courts asking our questions. That is why I replied to the excellent speech by the Chief Justice that it is important that it be the ordinary courts which operationalize themselves the answer of our court. This is simmental. And not everything is a conflict. So if you can reach the result which is in conformity with union law through the mechanism of harmonious or consistent interpretation, the matter is solved like this. And that covers more than 90% of the cases which come through references for preliminary rulings before the Court of Justice. That was already the case in the Van Gent and Loos case, where it was the Supreme Tax Court of the Netherlands, way back in the early 60s, asking the question. So we should really emphasize this and not sort of quantitatively exaggerate the scope of conflicts between union law and national law, including national constitutional law.
Thank you, President Leonards, for your response.
Maybe I could just pick up because we are really it is one of the dimensions within which the debate exists, and that also arose in the light of Egenbergen judgment, where the same thing as I'm saying now, the German Constitutional Court said, well, we would have solved it, of course, within the context of the national constitution, exactly the same way you solved it within the context of EU law. That's a real dimension of a discussion of this tripartite sort of situation, in this case, Supreme Court, Constitutional Court, and Court of Justice. And we should not, I think, shy away. There are, let's say not different, but there are sort of three courts with their choices that say, well, I could have done it as well, and I could have done it as well. There is, of course, on the EU law side, an obligation to refer if the applicable EU law is not clear. There is no question about it. But the point, and I do not have actually complete answer, the point I'm making is to remember that within a national level, indeed, a number of issues can be solved within the constitution context because the constitution is enriched by EU law. There is no doubt about it. But then what President Leonards said is very relevant. Then you have also a little bit of a judicial policy issue even, because, and that's what the Constitutional Court has done now by referring the private universities case to the Luxembourg Court. The reason is if you start feeling yourself more as a European judge, then something else hits in. You look at your case already, and we have discussed that with you, President Leonards, but you as a national judge, you look at your case not anymore as a narrow national dispute, but you look at it as something that is Europe-wide dispute, or meaning the legal question is of relevance and interest to everybody. Yes, I mean, in that context, of course, you would, channel it out of the national context because it can be helpful to everybody else. I mean, no question, it could be Supreme Court, it could be Constitutional Court. But the fact of the matter is that there are cases which can be solved by the Constitutional Court. It will be, of course, not the interpretation, like in this case, of the relevant regulation or directive. No way, because they were not clear. But it would be an important clarification of National Bill of Rights and the Fundamental Rights Charter, something that the Constitutional Court can do. So you see, yeah, that's the various, this is the Egyptian pyramid that we have been talking about in the Latvian context. Our legal system is not just a flat sort of triangle, but it's a pyramid which is formed by several legal systems. Thank you.
Thank you.
Well, dear colleagues, I understand that we are out of time, but I would like to express my gratitude to Mr. Leonards for reflection to our questions, and as well for the insight to the case of Kalmar and these legal issues touched upon in this case are very, very topical nowadays in Latvia. So, my impression is that we have gotten a huge amount of information, and we have to template on this how to apply to those applications to the Constitutional Court where applicant is contesting national law to the European secondary law. It is, of course, up to us to decide which is the best way, which is the best approach how to deal with these applications. And I hope when we will meet in autumn in Riga, I hope, we will continue this conversation. Thank you.
Thank you. Half an hour is gone. Like all today, time is running very quickly, and I would like make my concluding remarks. The European Union is a union of equals, and we are part of it. We all are judges of the European Union. The constitutional courts of the member states represent the will of their people, and all of this contributes to the core of the common legal European space. The Court of Justice of the European Union is already implementing the delegated will of our people at a supranational level in order to synchronize and effective functioning of the common legal space of the European Union. I believe that today's discussion has helped us to synchronize our understanding even closer. The courts need to talk to each other to improve mutual understanding. Usually, we communicate through our decisions, but today, with the help of the online streaming, we managed to listen to each other in a more informal way. We managed to spot a common outlook towards a shared goal by complementing each other's perspective. I'm sure we will succeed. And now, for the conclusion, I give the floor to President Leonards.
Thank you once again, President Osipova. I must say that for me, this experience of this webinar was extremely instructive. It is absolutely important for the Court of Justice of the European Union to do its work properly, to first and foremost understand the structure of judicial protection at large in the member states, not just limited to judicial protection of rights and obligations under European Union law, but let's say in general, at large. So I have now much better understood the relationship between the judiciary with, at its summit, the Supreme Court, and on the other hand, the Constitutional Court's proper role. I found all that I heard extremely instructive. Vice President Lovings, the Chief Justice, and my excellent colleague Ineta Zimele, who is really the natural bridge between the National Constitutional Court and the Court of Justice, and we are extremely privileged to have her among us. I think we should absolutely continue this debate because the in-depth understanding of the national legal systems, not just of one member state, but of all 27 member states, is the necessary ground layer for this Court of Justice, which is our Court of Justice. The Court of Justice of the European Union is a Latvian court, is a Belgian court, is a Portuguese court, is a Danish court, is a Greek court, and I can say that 27 times. It's our common court. And the common character of that court reflects the common character of the law, which this court is to interpret, apply, and enforce. It's our common law. And the national legal systems feed into that common character of that law. So we need the national systems as the first suppliers of legal principles, insights, values, fundamental rights, and so on. That is why this dialogue, informal dialogue, is so important. And it can possibly one day also be more formalized, like Judge Ziemele said, and she knows I share these views. We only have to think together again how we can operationalize these ideas, and not just with one constitutional court, but with several constitutional courts, and even including courts like Hoge Raad der Nederlanden or Høyesterett of Denmark, which in fact are not constitutional court, but fulfill the same role next to that of being a Supreme Court. So you can all count on me as president of this Court of Justice, our common Court of Justice, to be as useful as I can in promoting these ideas. It was a fantastic webinar. I keep many ideas which we will further reflect upon, and I'm really looking forward to come to Riga, celebrating the 30th anniversary of the Latvian Constitutional Court, at the same time of the recovery of Latvian independence. It will be a fantastic seminar, and on this side, together with Judge Ziemele, we will do everything to make it a resounding success. Good afternoon to all of you, and thank you so much for having organized this unique event. Thank you.
Thank you, President Leonards, for your kind words. It was exciting webinar, and thank you to all the speakers for your great lectures, for excellent questions, for interesting response. Thanks to everyone who followed us, followed this discussion on YouTube, and see you next time. It was very interesting, it was very exciting, and I think we will continue our discussions in next meetings. Thank you very much. Good afternoon.